This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
On a surprise to the profession and to the community of lawyers, what transpired on February 11, 2019, the NDP government unilaterally restricted the number of expert reports that you can use and experts you can use in a claim, regardless of when the claim arose. So that includes before the no-fault scheme accidents, which is April 1, 2019, so for everyone. So what they've done is basically for an injury claim that is what's called fast-track litigation, something that generally would be under $100,000, they've restricted the number of expert reports and experts to one. And for every other claim, no matter how catastrophic the claim is, so somebody with a quadriplegia with a brain injury, they've allowed only 3 experts and 3 reports. And the reality of that situation is the NDP government had indicated that they anticipate saving anywhere from $300 million to $400 million on expert report expenditure. But the bigger issue is they're actually going to be able to severely restrict the ability to prove your claim. Because just using a simple example, if somebody suffers a knee injury and a psychological injury or a brain injury and is being off work and has to be retrained for the job, I can give you an example. Without splurging on expert reports, you'll need an orthopedic surgeon for the knee, you'll need a psychiatrist, neuropsychologist, or neurologist for the brain, the psychiatric issue, and then you'll also need a functional capacity evaluator, and also maybe a vocational assessment. And then of course you need to hear what the treating doctor, like the family doctor, has to say. So right away you're into 5 to 6 reports for a decent sized file, which involves fairly significant injuries for an individual. So if you're restricted to only 3, then clearly you will be unable to prove injuries. So for example, how do you prove the knee injury and the head injury? How do you prove the time off work or the inability to work in the future without the multiple reports? And what transpired is basically the government, without thinking it through, could have simply capped out the amount that an expert could charge, and they could have saved a lot of money, but they didn't. They capped out the number of reports because that's a tremendous advantage for ICBC and the defense lawyers, because it would be a rare file where a defense lawyer in ICBC needs more than 3 reports. So they didn't get any restrictions. It's all about the injured party, and the people that are most affected aren't the people with soft tissue injuries, it's the people with the catastrophic injuries, because it's impossible to fully flush out and prove the claim. And the plaintiff the injured party has the burden of proof. So it's impossible to fully prove the claim with only 3 expert reports. It'll be interesting to see how the courts address that, because it is a clear situation where the administration of justice is put into disrepute, meaning that it's unfair to the claimant that they aren't able to fully prove their claim. And so this is a policy that I personally feel is a very negative policy to the very severely injured people that suffered car crashes in the province of British Columbia.